full sign yet. The meeting is being live streamed. Got it. Good morning. This is Senate Judiciary. And we are meeting today on S-180, a bill that would aggregate in certain circumstances the amount of the theft. And it addresses a problem that's kind of nationwide right now, where people go into stores and steal a number of items, sometimes not as valuable as others, but we've all seen it on the news. And I really thank Senator Baruth for introducing this bill. After I saw it, I said, wow, I wish I had thought of that. So, Senator Baruth, why don't you take over and introduce the bill, and then Eric will walk us through it.
Okay. Thank you, Mr. Chair. So again, we are here for S-180, aggregate retail theft. And the genesis for this bill came from two different places. The first was Bonnie Ryder, who is my sister, works at Kohl's in South Burlington. And over the last, I would say, year, she's been involved more and more with trying to prevent retail theft and that loss at the Kohl's store where she works. So over those months, we've talked again and again about how much theft is going on and how brazen that theft is. So that's happening on the one hand. And then, as all of us are occasionally, I was contacted by the merchants in my district from the Church Street Marketplace, and they were experiencing very much the same thing at record levels and really pulling their hair out. Among other things, we lost our LL Bean store, which is going to move out of downtown Burlington. Part of the reason that they stated was retail theft. They, I think, had other reasons, but on Church Street and in our, most heavily trafficked stores in South Burlington, Williston, other places in my county, it's become an epidemic of retail theft. So I, working with Jeff Nick, chair of the Church Street Marketplace Commission, Eric and I attempted to rough something out. So S-180 is not presented as a finished product, really. It's our best thinking at the moment about how to address this situation. But I just want to say that there are a couple of different strands to the problem. So one is what has come to be called organized retail theft, where you have gangs of people working together, maybe two, maybe as many as we've seen out on the West Coast, as many as 15 who come into a store and work in concert. We haven't really seen that in Burlington, but we have seen 2 or 3 people working together on a regular basis. So one question is, how do you address that sort of organized activity? Then Jeff Nick was particularly concerned about smaller retail theft that happens on a very regular basis. And his example for that was CVS Pharmacy. Nothing in CVS is really that expensive, but people coming in on a regular basis and stealing $100 here, $100 there. One of the issues there is the threshold for certain theft offenses and whether those thresholds are too high for the police to routinely get involved. And then the other and the last strand is what I'll toss over to Bonnie Ryder when she testifies, and that is one person who is stealing large amounts of stuff, and in some cases filling shopping carts and just walking out with them. So the question is how to address these related retail theft problems. As I say, S-180 is a stab at it. I'm hoping that the committee can get its arms around the problem and maybe draft other pieces to add to the bill. But it is what it is now. And with that, I'll turn it over to the next witness, Mr. Chair.
Thank you. Eric, do you want to walk us through the bill as introduced?
Yes, happy to. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here to walk the committee through the Bill S-180 as introduced. The S-180 is an act relating to the aggregate value of stolen property in certain crimes. As Senator Baruth explained, there's a genesis of the bill and the threshold between property offenses that are misdemeanors and property offenses that are felonies. That's really what the bill turns on. And Senator Sears, if it pleases the committee, I could pull up the bill. We could take a moment to look at the language.
Yeah, it's rather short, so I don't think that should be a problem to share the
Okay.
screen.
Yeah, right. Thank you. So here we are at S-180. As I mentioned, and again, I can't see anybody while the screen is shared, so please feel free to interrupt me or if you have any questions or comments as I'm proceeding through the walkthrough. But as I mentioned and Senator Baruth mentioned as well, this really turns upon the threshold that exists in existing law between misdemeanors and felonies with respect to these two types of property offenses. Now, the two types of offenses that we're talking about in the bill are grand larceny and retail theft. And they both deal with the same or similar types of situations. They can both cover the same situations. But basically, you'll see the grand larceny, that's existing law right now, looking at the screen in lines 14 to 15, has to do with stealing from the possession of another person. So if you steal from the possession of another person, grand larceny. Now, on the other hand, but similarly, retail theft, just looking at the existing law for a moment, you'll see retail theft also involves stealing, but in this case, it's from a merchant. So that's the difference between the two. Grand larceny from any other person, retail theft from a merchant, steal merchandise, money or credit. Now, you have grand larceny is a, depending on the amount of property that is stolen from the other person, it could be grand larceny, it could be known what's called petit larceny, which petit is French for small. So you have your grand larceny, your petit larceny, and the distinction is how much was the property valued at that was stolen, and the threshold is $900. So, and it's the same threshold, the $900 threshold exists with respect to retail theft as well. And some folks on the committee may remember, because it's obvious, a question might arise as well, how did that $900 figure get chosen? And I recall it was probably at least 10 years ago, or in the neighborhood of 10 years ago, that the question came up of what was the right number for distinguishing between felonies and misdemeanors for purposes of these property-oriented crimes, because it had been, I believe, before that, I don't know if it was $250 or $500, it had been a small amount, it hadn't been changed for a long time. So there was a summer study committee that looked at a number of different issues, but it looked at that issue in particular as well. And I believe there was some back and forth on the committee as to whether or not it should be $750 or $1,000. So the compromise was $900. So that's where that $900 came from. And it still exists in quite a few different property offenses that you'll see. It isn't just these two, in various places in Title 13, where there's a distinction between a felony and a misdemeanor based upon the amount of property involved. You'll see that $900 figure quite commonly. So this particular bill, though, addresses only two of those offenses, larceny and retail theft. With respect to grand larceny and petit larceny, the petit larceny offense, again, if it's $900 or less in stolen property, that's a 1-year misdemeanor and a maximum $1,000 fine. So again, $900 or less, 1-year misdemeanor, $1,000 fine. Grand larceny, on the other hand, in other words, if it's more than $900 in stolen property, it's a 10-year felony, $5,000 fine. Maximum, of course, those are just maximums. but still pretty significant difference between the two offenses based on the amount of money involved. Similar distinction in the retail theft context, again, has to do with the amount of property involved. And this is all current law, by the way. So again, if it's based on the $900 threshold, if it's $900 or less in merchandise that's taken, then for purposes of retail theft, that is a 6-month misdemeanor, $500 fine. So if it's more than $900 worth of property, then it's a 10-year felony, $1,000 fine. So similar distinctions. Amount of incarceration time is a little bit different. It's a 6-month misdemeanor for retail theft, whereas it's a 1-year misdemeanor for petty larceny. But both of them are 10-year felonies if you cross that $900 threshold. So that's the state of the law. That's the existing law, and that's sort of the context in which this bill was drafted, as Senator Baruth indicated, to address a particular issue that's been happening out there in the communities. So the idea here is that, okay, you have that threshold, but there's going to be a way in which that threshold can be exceeded through multiple actors acting in concert. That's the idea behind the bill. So just using the language between the larceny section and the retail theft section is virtually identical. So, but we'll look at the larceny one just to understand how it works. So again, what the language provides is that it shall be a violation of subsection A. In other words, it will be grand larceny, right, rather than petty larceny. So it would be grand larceny if, so even though you ordinarily have this $900 threshold for a single offense, here we have, in a sense, a carve out for that. So it will still be a violation of subsection A if a person acts in concert. In other words, acting together, and I'll get to that language in a moment, but acting together with another person or with one or more persons on one or more occasions within a period of 180 days. So it could happen, doesn't have to happen at the exact same moment. It could happen within a 6-month period. And if they act in concert with one or more persons to commit that offense, and I say that offense, the offense of petty larceny, in violation of section 2502, and the aggregate value exceeds $900. So in other words, if you think about how that would work in practice, you have a single offense perhaps would not exceed that $900 threshold. But if that person is acting in concert, acting together as part of a common plan with somebody else within a period of 6 months, and it's still each offense viewed alone was less than $900. But if together the aggregate value was more than $900, then it could still be prosecuted as grand larceny. So just to pick, 2 random examples, but say 2 people as part of a common plan, each steal $500 worth of stuff. Well, individually, each of those offenses would only be petty larceny, subject to the 1-year misdemeanor. But if they happened within that 180-day period and it was part of a common plan, then you could aggregate them. So the 2 $500 offenses added together would be a $1,000 offense, and that could be prosecuted as grand larceny. And that's the fundamental idea behind it. You'll see that the retail theft provision takes exactly the same approach. Again, retail theft, as I mentioned, is stealing merchandise from a retailer as opposed to just any other person. But again, the language is the same, that subsection B is the one that involves, and this is line 6, the felony, the 10-year felony, because the amount of property stolen is more than $900. And you have language proposed to be added within subsection B that says a person shall be punished pursuant to this subsection. In other words, it would be the 10-year felony that would apply if the person, again, acts in concert with another person within the 180-day period to commit a retail theft offense, which would, standing alone, be less than that $900 threshold. And if they engage in that conduct, then the amount of property taken away can be aggregated. And if the aggregate value exceeds $900, then the persons would be subject to the 10-year felony rather than the 6-month misdemeanor. And that's the theory behind it. The the idea, I just want to show, I think one sort of question that would naturally come up is, well, what does in concert mean? What's the definition of that? What might that look like? And the language I have on that in a moment here, we'll be able to expand that for you. Well, it's not popping out. So you can see here, though, if you look on the right side of the screen. Yeah, sorry.
Note to self.
All right. Yes, that's funny that I actually like the way that happens when you email send an email to yourself. Outlook automatically populates it with a subject handle that says note to self. It can be very helpful. But that one is not where I'm looking to go. So let's see. So it's right there. But for some reason, here we are. So if you look on the right side of the screen, actually here we have several different places. Now the term is used in Vermont statute in several different places. I found several different places, but it's never defined. So at least in the Vermont statutes, I didn't find a definition, but it's used in a couple of other criminal provisions and a couple other places in Vermont law. So it's certainly a term that is known, but there isn't a specific statutory definition anywhere in Vermont. But I looked at a couple of other places just to sort of help understand the concept. There was a Vermont Supreme Court decision you see on top there, Montgomery v. DuBois. It was in a context of a civil case, but it described acting in concert as meaning pursuant to a common plan or design. Now, the restatement of torts also involves civil lawsuits, in other words, lawsuits based on conduct of which someone was trying to recover damages. But in that context, the restatement does define in concert, and it's defined in that provision as in accordance with an agreement to cooperate in a particular line of conduct or to accomplish a particular result. There's also a definition in the federal security regulations under the Code of Federal Regulations, and they define it as knowing participation in a joint activity or parallel action towards a common goal. And lastly, I thought an interesting one was in the Arizona Joint and Several Liability Statute. Acting in concert means entering into a conscious agreement to pursue a common plan or design. So that common plan or design concept seems to recur pretty frequently, but thought it would be helpful to at least see some other legal authorities that have defined that term. I'm going to go back to the Zoom screen now, and that's actually the end of the walkthrough of the language, which I could continue with the language still on the screen or take it down, whichever you prefer.
I think taking it down is probably easier for us, if you don't mind, Eric. Thank you very much.
Sure.
It does raise a couple of questions. So the person going into CBS, Eric, and by themselves on day one steals 4 gift cards worth $100. And then the next day, another 4 gift cards worth $100. And then the next day, another 4 gift cards worth $100. I mean, $400. You've already up to $1,200 for those 3 days, but that's not aggregated because they're by themselves.
I think that's right. I think that's the way I would read it. Yes.
So
but it's
I would say that.
Sorry.
I just wonder, and secondarily, how would you prove that somebody else was involved? Maybe they're, involved with them, but they would never admit that, and they're just there to hide the theft.
Well, certainly the proof issue is something that will come up. That you would have to be able to. The prosecution would need to come up with some evidence that common plan or design existed, whether it be, somebody testifying about conversations between this group of people or some other evidence, someone who had observed conversations, whatever it may be. You're correct that that you couldn't make that case without some kind of proof of the common plan.
Senator Bruce, did you have a comment? And then Senator White has.
I did. You put your finger on the piece that I'm hoping we could work on a little as we go along with this, which is what you see there is the organized retail theft part. But the other problem, specifically that Jeff Nick was concerned with, is exactly what you describe: a single person on multiple occasions coming in and stealing less than $900, and then the police aren't interested because it's petty larceny. They're busy elsewhere. So if there was a way to add language that would speak to what you're talking about, that would be very much in line with where we were hoping to go with the bill.
Yeah, I would think you could just put in by themselves or with another.
Yeah.
Another. Yeah, Senator White.
So one of the things that I understood was the problem is that people aren't necessarily charged because they're stealing $40 worth of something or whatever. So what this implies is that every time somebody steals something, you're going to have to file a charge and you're going to have to prosecute them. Otherwise, there would be no way of adding that up. If a merchant wants or somebody wants to be covered under this, they are going to have to charge every time somebody steals a pair of socks, because they might be stealing in a 6-month period of time. They might be stealing a lot. Do I understand that, Eric? They would have to charge because otherwise there'd be no way of showing what they were stealing.
No, I think that they wouldn't necessarily have to charge on each individual occasion, as long as there was an ability to come up with some evidence that the theft occurred and that there was some kind of an agreement or plan with some other person to steal other things. So if there was evidence that they had to establish that the theft occurred, perhaps someone who worked at the store saw them take it, something of that nature, then one could conceivably bring this charge. Again, it depends on the proof, for sure.
So, but you'd have to have some kind of proof. It isn't just the clerk saying, so they're going to have to be confronted. They're going to have to take a picture. They're going to have they have to do something to prove that this person stole this.
Yes, absolutely. There'd have to be some evidence, for sure.
And I think when you hear Bonnie Ryder's testimony at Kohl's, and obviously this wouldn't apply to small merchants, but at Kohl's they have a very sophisticated closed circuit system, and they have pretty good estimates for what people are stealing, and they're all on camera, obviously, when they're doing it.
Senator Benning has a comment or question.
Question, Eric. Every time a theft occurs, an individual could be, whether they are or not is irrelevant, they could be charged with a petty larceny. Over time, these separate petty larcenies, if they fit within the window of this statute, could then be used as an aggregate offense. Are there any double jeopardy issues about somebody being charged with each individual offense as well as being charged in the aggregate scenario?
It's an interesting question. I haven't looked into it, so it's possible. I would think that, again, it's right off the top of my head, but I would think that you probably couldn't be charged with both. That an individual, say you were charged for the theft of $100 gift card, and then you were then there was an attempt to prosecute you for an aggregate using that same $100 gift card. There may be a double jeopardy issue there. I guess I would want to look into that before I answered.
Okay. I'd like to get an answer to that question, because if I look at from my normal job's perspective, I could see a prosecutor trying to string out several misdemeanor cases in order to reach the aggregate and then have them all served as consecutive sentences, which might put a different spin on how I vote on this.
So, and also, I hate to mention geographic justice, but in some counties, the stealing of $100 is ignored. In other counties, they're prosecuted. In other counties, they're diverted. So I think you have that as well. But I think this is getting at organized shoplifting, just using it in general, where one or more people act in concert to steal large items. And I think generally many of the merchants, don't want to get involved in threatening or in reporting it out of whatever reason. So, we all end up paying for that, by the way. But I hope that those closed circuit TVs are good, because I saw one yesterday of somebody hit a pedestrian in the Walmart parking lot in Bennington. And the video was so bad that you couldn't even identify the license plate of the driver. So, other than it was a white SUV with a heavy set person. Why don't we turn, if there aren't any more questions from the committee or clarifications, why don't we turn to our first witness, who is Roger Marcoux, who is the sheriff in Lamoille County. And the head of the I believe the vice president of the Vermont Sheriff's Association.
Yes, Senator. I'm a little confused. Are we still talking about retail theft?
Yes.
Okay. I was unclear. I received an invitation and I just showed up. So
thank you for doing that.
yes,
Yeah.
you're very
We're
welcome.
talking about S-180, the bill that would aggregate retail
Okay.
theft.
So forgive me for shooting from the hip, but I think you probably know me well enough, Senator, that I will give it a good shot here. First of all, Senator Baruth, I applaud this, you looking into this, and thank your sister. Here, we're dealing with a rural county here in Lamoille. And I have had the type of problems that we have here with retail theft are mostly when you really investigate them and everything, they relate back to some kind of an issue with involving drugs. But the problem that we have here is, for example, in the last 2 or 3 weeks, we've had individuals that every day when they need something, they go break into one of the convenience stores, and those are break-ins, or else they'll walk out with cigarettes or what have you. And really, we're so far behind in our court scheduling right now that it's could be a couple of months before those folks get before a judge. So I'm just kind of wondering, and listening to everything so far in terms of the in concert with, and it's a question maybe for Eric, is do we not have a conspiracy statute that would overarch this and look into all people involved in a crime? So that's kind of a question I don't have the answer for.
Excuse me, I've got to go to Senate Agriculture, and I'm going to try to figure out how to do that and then come back. But thank you. Senator Baruth, if you could take over.
Go ahead, Sheriff.
Yes, in the I worked in the federal arena for about 20 years, and we had a conspiracy statute there that anybody that conspired to commit crimes, there was specifics that were specific law that addressed those folks. But my concern is how do you get to 900? Just what everybody was saying. How do you get to 900 if they're stealing $40, $50 every day. And I have one particular fairly significant business in the county here that is just irate. I mean, they had a guy who stole a wheelbarrow and filled it up and was walking it down the road when we caught him. Welcome to Lamoille County. And so we cited that person in the court, and then the next day he was right back at it with another merchant and what have you. So, and then you've got the people that may steal $40 from one store and then go and an hour later steal another $30 from another store. To Senator Benning's point, how do we fairly manage that to make sure that the victims are thought of and addressed, and meanwhile not clog up the courts and sort out the people that are doing this because they have a substance use disorder problem, as opposed to people that are doing it for a living, stealing stuff and then selling it again. So I'm sure that's of no help, but
I thought it was helpful. I will just say on the wheelbarrow example, Ms. Ryder sees this all the time at Kohl's with shopping carts, people just wheeling a cart out to the parking lot. So I think whether you're from the city or from the country, it's gotten to the same place. Questions for Sheriff Marcoux from the committee? Okay, Sheriff, anything else you'd like to tell us?
No, I apologize. I'm not more prepared. I didn't know which issue we were going to be talking about today.
Not at all. We know you're busy, so thank you for coming. Next on the witness list, we have Matt Valerio. Morning, Matt. Your audio is a little faint.
I just wasn't speaking very loud.
Oh, there we go.
Okay, well, I've had a chance to take a look at S-180 and to do some research on it. I am always heartened to know that those that don't practice law, particularly criminal law, when they come up with an idea like this, pretty much would guarantee a number of lawyers' business for the next decade, litigating something that is frankly already covered by Vermont law and in a bunch of different places. It's interesting to me that it wasn't that long ago that this threshold amount was changed from $100 to $900 to distinguish between felonies and misdemeanors, and it was the result of two things. There was the original Criminal Code Review Committee, which I was on with law enforcement and prosecutors and AGs and the like, and also that became the first sentencing commission, which led to Justice Reinvestment 1. And one of the things that it looked at that time was whether or not the thresholds for between misdemeanor and felony were appropriate, given that they hadn't been changed in decades, and I mean 50, 60, 70 years. And so one of the things that, and Eric brought this up earlier, one of the things that happened is they went through the code and looked at property crimes in general and created a threshold of $900. Interestingly enough, the retail theft one did not change, and there was significant lobbying at the time by the Grocers Association and the retailers associations to not change it. Ultimately, it was changed. As you can see, it did go to $900 to match what was going on with the rest of the misdemeanor, felony, property crime thresholds. One of the things that was brought up by Sheriff Marcoux was that there are, in fact, three different, he mentioned one of them, but there are three different areas of Vermont law that already cover this activity. One is the aiding statute, and there's a case that directly on point, the State versus Brunel case. It's a 2008 case where the people acting in concert to deal with stealing things from a merchant was identified as an aiding offense that could be charged depending upon the aggregate value of what was had by those individuals. So aiding and accessory are related. There's the other portion, and then we've talked about this before in a different context, the whole concept of aiding, accessory, and conspiracy. Vermont also has a conspiracy statute, as Sheriff Marcoux indicated, and it doesn't necessarily override this, or it wouldn't. The litigation would be around how is it different, and which one? Why would you charge one versus the other? Courts are going to try to distinguish the statutes to make sure they all work together. In this case, to me, the language that Eric was pointing out from the restatement and the like is kind of black letter law that deals with accessory, conspiracy, and aiding. It's all the same language. And when you determine whether or not somebody is, doing felony activity, you are aggregating the amount of whatever the loss is in the aiding, accessory, and conspiracy statutes. The other thing that I believe covers this activity is the felony and misdemeanor possession of stolen property statute. So if you end up, you aren't going to be charging, you can't, if you don't know who did the actual stealing, but if you come to a place and you find individuals who have stolen electronics, or they have stolen from various places and they've stored them in a spot, the aggregate of that value is covered by the possession of stolen property statute. The ability to prove in concert is always the difficulty with any sort of aiding, accessory, or conspiracy crime. That really depends upon the facts. And one of the things that is a defense to any of those, and it would be a defense to this, is whether an individual has withdrawn from the common scheme or plan. You might have a plan in advance, and then somebody goes forward and steals whatever they were supposed to steal, and along the way, someone says, I'm out of this. I'm not part of this anymore. Well, withdrawal from the common scheme removes an element from this. Given that this is over, that the statute for the in concert portion talks about over 180 days, the aggregating portion. I think there are constitutional issues about the remoteness of time. I don't think it's a double jeopardy issue, Senator Benning. I think the issue is whether or not the misdemeanor versus felony, and how this aggregates is whether it's a lesser included type of situation. And I don't think that it is, because you have to have identity of elements. The real question is whether you have identity of elements as they apply to the aiding statute, the accessory statute, the conspiracy statute, or the possession of stolen property statute.
Could you explain? I'm not familiar with lesser included.
Yeah, so if, for example, if I kill somebody, a lesser included offense to a first degree murder would be a second-degree murder, because the elements of unlawful killing of another, the differences are the same. The difference is what the intent was, the mindset. And under that, you also have voluntary manslaughter or involuntary manslaughter. So if somebody gets charged with first-degree murder, they are, for the most part, unless they really feel like there's no way they're going to prove that, you're going to request jury instructions on lesser included offense. So the same activity would be a crime of those lesser included offenses, as opposed to just the whatever the maximum was. So that's why I think in this case, if somebody charged the felony aggregating or the in concert portion, the state's attorney would probably still be able to bring the those lesser included offenses in case they weren't able to prove the most serious offense. It's also something where a defendant could request the lesser included offenses be charged to the jury. The issue of double jeopardy is whether or not the activity itself gets charged in one case and gets adjudicated, and then down the road, the state's attorney within the 180 days wants to aggregate that first crime with their second, third, fourth, whatever it might be. They probably would not be able to do that based on double jeopardy if the activity arose out of the same already charged offense. One of the things I also worry about here with this kind of thing, especially where you have tools in Vermont law that cover exactly this activity, is whether you're going to achieve the desired result. The increased penalties, there are studies nationally and within the state, do not deter crime. The only thing that deters crime is the likelihood of you being caught. And in a prior life, I was director of security at a hotel, and we had obviously theft issues there, and employee theft was not uncommon, and obviously guests stealing things. And one of the ideas was, well, we were going to up our video surveillance technology, make it much more pervasive and the like. That didn't deter anything. The other thing, and so we went back to the drawing board, and one of the things that they talked about is to make sure that our security staff was uniformed. When we were ununiformed, and I was director of security, so I was always in a suit. People didn't know, except for those who did know, that I was the director of security. Once we went to uniformed, we cut our theft by 50%, and it's because people had the perception that, oh, there's a guy in uniform, I can't do whatever I'm going to do. The cameras didn't do anything. We quote unquote caught them because we could see them. And the other thing that we did is that we set up a couple of sort of stings where we caught the chef stealing a side of beef, that kind of thing. And that spread throughout the hotel community. And this was, I was at the Sheraton in Sturbridge, Massachusetts, and I had this job when I was in law school. And once we put uniforms on the security guys who were walking around, once we caught somebody and they knew that they could get caught, then things quieted right down. But we had a real problem. It wasn't the fact that it was a crime. It wasn't the fact, a side of beef was a felony. That was big value back then. But once that became known, then the issue stopped. And I think that one of the problems that maybe, the Burlington area has. And I am very supportive of a lot of the things that Sarah George does there, trying to get a handle on the important types of crimes that are really, killing people, frankly. But I think there's a perception that people aren't going to get caught. And if law enforcement is saying we're not going to spend our time on $40 thefts or $50 thefts, and the prosecutor's saying this isn't what we're going to charge, then you got a problem in a particular area, because the one deterrent that the statutes or that the studies tell us is going to work, which is the likelihood or your belief that you are going to be caught, is not working. So changing the statute, I don't think is going to get you there. We're going to have a lot of litigation around what all of this means and the constitutionality of, I think, the aggregation and the 180 days. Both of those issues are, the interesting part about it is the aggregation is something that's covered by possession of stolen property. So if you catch somebody with a room of stuff, you don't charge them with, each item on the value. You charge it with the aggregate value of the possessed stolen property. So there's probably something to that constitutionally being done. The question is limiting it, over a 90-day period of time. I just don't know how it's going to work out. I can see the issues. I ran this by the appellate division yesterday. What they basically confirmed to me is what my original thoughts were, that it is already covered under the aiding, accessory, conspiracy statutes, and would also be covered under felony and misdemeanor possession of stolen property. But apparently those aren't enough to do the job right now. And I think you've got to look elsewhere to try to address this problem.
Mhm. Well, thanks, Matt. I appreciate that. And that's a lot for the committee to consider. I take your point, especially about some sort of demonstration that it's possible to get caught. One of the things that's disturbed me from the beginning in thinking about this is the idea that, as Sheriff Marcoux was saying, you have somebody walk out with a wheelbarrow full of stuff, or in the case of Kohl's, with everyday shopping carts full of stuff. People clearly have the concept firm in their mind that they won't be pursued, that they won't be caught. So are there questions for Matt? If not, I will turn over to Bonnie Ryder, and among other things, we can try to get a little bit of testimony on at least the brazen nature of the thefts under our current statutory scheme and enforcement scheme. Ms. Ryder,
Yes.
if you would introduce yourself, and then floor is yours.
Okay. I'm Bonnie Ryder, and I work at Kohl's in South Burlington, but I'm not here representing Kohl's. I'm just an individual that witnesses theft every time I go to work. So I'll just read what I have here. I've taken it upon myself to deter as much theft as I can, because I feel that I have to do whatever I can legally to stop it. We don't have any loss prevention staff at the store because there are no good candidates, despite the job openings being open for a very long time. This is a part-time supplemental job in addition to my day job at the school district, and literally every night or weekend day I work, there are several people that come in individually or in groups just during the 4 to 6 hours, 4 times a week that I'm there. So much more that I hear when I'm not there. As soon as I see or I'm told there is someone that might be suspicious, I head to that location and offer customer service. I do what I can to head them in the direction of the checkout line, but in most cases, they divert and run out the door. The majority of them come in with their own backpacks to stuff the items in, or they steal the Kohl's reusable bags that are for sale and fill those up. They fill up a cart, or they just fill up their arms and run out the front entrance or the mall area. A lot of times they knock into people coming in the store. The thefts that I have deterred myself value at an average of $500 to $1,000 per incident. Sometimes there's a getaway car or a van they run to and get picked up. Many times they leave the store and go out to the bushes and leave the stuff with whoever is hiding in the bushes. Many times the people run out the alarm doors in various parts of the store to get away with the stolen items. Many of them try to be intimidating, and many know that they can just walk out with whatever they want. There is not a lot of police presence in the parking lot or in the mall, and I'm not sure why. I know the theft that goes on at Kohl's, but I hear what happens in the mall as well. The theft that is going on has grown significantly, and the police should be more involved. Thank you for listening and having me here.
So one of my questions in discussing this with Bonnie was why the Kohl's management doesn't contact South Burlington Police, have them sit in a car outside and be in radio contact with the people on the closed circuit TV. And as somebody exits the store, just take them into custody. But that's not a question that I've been able to get an easy answer to, because it seems as though this is a group of people who are over time targeting Kohl's. They're local. They know that there's a policy in place not to confront them. And so it seems like in the absence of the police stepping in, there's not going to be a solution. So really the impetus for the bill is to try as much as anything to motivate police to view these as offenses worth treating. Senator White.
Thank you, Bonnie. One of the things that you said, and I'm not sure if I heard you right here, was that because you haven't been able to hire security people because there are no, there's a lack of applicants and there just isn't the pool out there. But so going back to what Matt Valerio said is that when they increased their, well, I don't even know if they increased their staff, but they just put uniforms on them, it made a huge difference. So, and I also know that that law enforcement itself is very understaffed and is having a hard time hiring people. So I guess my question is, I understand it's hard to hire people, but if there were uniformed security people in the store, do you think that would make a difference? And I hesitate to create a law making something a felony because of lack of staff. Does that make any sense to you at all, what I asked?
It does. It definitely would help if we had loss prevention, uniform, most likely uniform. But they can't be in every place at every time either. So we would have to have two, one at each entrance. But until that happens, we have people coming in just, it's unbelievable what they do and how brazen they are.
I do understand that, but I'm a little bit nervous about creating a felony here because of inadequate staffing.
Mm-hmm.
I don't think it's just inadequate staffing. It's right.
And
the amount that is going out the door each time.
Probably be cheaper for Kohl's to hire people than to lose all that.
I agree. And, you know, there are multiple things about the situation that makes me scratch my head. So this has been going on for months and months. So I know that Kohl's has been in the process of trying to hire and has been having great difficulty. Back to the Church Street Marketplace Commission, I believe tomorrow we'll have testimony from the manager of Outdoor Gear Exchange and Burlington Better Business. And I think their concern is more the smaller thefts that are repeated by one individual over time. So I take the points that we've had from Matt Valerio and Sheriff Marcoux and Senator White and Senator Benning. There are thorny issues with trying to address this. I see Senator Sears is back. Senator Sears, we just heard testimony from Bonnie Ryder.
Oh, I'm sorry, I missed it.
So I believe we're at the end of the witness list for this segment.
Okay. Wow, I didn't realize we did that.
I apologize. Jeff Nick, who chairs the Church Street Marketplace Commission, I had been in touch with him about other witnesses. He turns out he's out of town today, and working with Mike Ferrant, he hooked up a few more witnesses for tomorrow morning. So that's why there's I think a little.
I
bit of a
see
hole
that
in the-
11 a.m. we got them scheduled, but I
Yeah.
really missed. I guess Mike has done a terrific job trying to fill in for Peggy, but in the scheduling, I missed that we were done with witnesses on Wednesday morning, and so I'm not going to keep us here much longer. Yes, we're. Roger, did you have a comment? Yeah, please.
If we're at the end of the conversation, I was going to ask Bonnie Ryder an off-topic question. And no, Bonnie, it's not about your brother. I just as soon take you out to lunch to learn that part. But I was curious as to whether Beth Cobb was your superintendent.
No, Tom Flanagan is the superintendent.
Okay.
Right.
She and her husband happen to be good friends of ours, and I was just wondering if that was a connection. Thanks.
You're
I think
welcome.
Roger Marcoux has a comment.
Yeah, thank you. Hopefully it's appropriate. I just wanted to comment on a couple of things I heard, and people not fearing getting caught. The situation, I think, if you talk to a lot of law enforcement in the state, isn't. There are departments that don't respond, but there are a lot of departments that do respond, and the fear more is that there are no consequences for getting caught.
Mhm.
And I can speak to this. My wife is a victim's advocate with the state's attorney. And the other thing that I'll mention is, even if this bill were to pass as is, we still have the issue of state's attorneys willing to take it on because of the priorities of how busy they are and everything else. So for what it's worth, I thought I'd just mention that. Thank you.
For some reason, my internet's unstable, and people have frozen, and I can't see anyone other than Bonnie, Joe, and Roger. I don't know what's happened to my internet. But,
Oh, I guess you can see the best looking.
Thank you, Senator White. I can't see you. Oh, now I can. Oh, good. Mike, unless there's anything else on this, let's do our best to fill in Thursday and Friday. I hate to lose 2 hours of valuable committee time, but it looks like we're pretty well done here, which will give me an opportunity to fill out my sworn statement that I've been vaccinated for the President Pro Tem. Let's see if we can work on Friday